No.
May it please the court. I'm Larry Boyd from Rogersville, Tennessee, part of the Rogersville Bar. I'm here representing the Berry family, and the gist of this case begins with the recording of this plat.
Counsel, do you want to reserve any time for rebuttal?
Yes, I've reserved it.
You've already told her, thank you.
3 minutes.
Sorry to interrupt.
I'm sorry, Your Honor. I should have told you that. But recording this plat, the Clemens family, and it was a plat that didn't have a deed to the county for the property, and the plat was never developed, and it remains pretty much the same as it was in 1956 when the plat was recorded. And the condition on the issue was, the reason it's here is because sometime after 1956, about 1960, a successor entitled to the Clemens family who developed that built a garage on part of the unopened, developed part of the subdivision, and that garage is the subject of this litigation here today. The garage has been there for more than almost 70 years, really, if you count soon. But the issue is there was never a deed made to the county for the property, and the issue, one of the big issues is, was there an offer? Yes, there was an offer when they recorded the plat. Was there an acceptance? And that's what we say, there was no acceptance. Now, the judge ruled in that case, and we feel like that's something that the court needs to take a long look at. There's two cases that the court seemed to rely on. One of them was Varallo, and the other is Westmead. But in the Clemens subdivision, there was never any utilities recorded. There was never a paved street, and there's never been a sewer line put in. In Varallo and in Westmead, there was a 60-foot street in Westmead that was developed. It had sewer lines, and in the present case of the Clemens subdivision, there was never any utilities put in there. There was never a public street, and there was never any kind of utility poles or anything like that, water lines that furnished the subdivision. So our argument is that there was never an opening, an acceptance of this subdivision. Now, what the Smiths rely on is that this resolution, there was a 1959 resolution adopted by the county commission. There was never any notice published in the paper about this notice. There was never any publication in the newspaper or anything of that nature of this resolution being passed. But the part of the resolution that is suspect, which the judge seems to rely on, it has a condition in it. And the condition of that resolution says in there that expeditiously acceptance by the county when the road committee and road superintendent is able to commence the working and the maintenance of the roads. And there's never been any working and maintenance of the roads in this case. There's never been any development of it.
So let me ask you a question here, counsel.
Sure.
It's Hyder Lane is the name of the, is that correct?
Yes.
I couldn't tell from the Bruce whether 1/10 of the mile or 1/10 of the length of Hyder Lane.
Undeveloped road that was 1/10 of it was
okay, so it was
built by somebody, not necessarily by anyone else,
Okay.
but built by somebody down to my clients who's the Berry's residents.
Well, is there any disagreement that that part of Hyder Lane is a public road?
There's never any disagreements because the judge, in fact, I mean, not the judge, but the road superintendent, in fact, said that he patched holes and that he maybe put some surface down at that point. But it goes down to the residents of my clients, and then from that point on, there's never been any development, and there was never any utilities. There was never a sewer line put in there. There's never electricity in there. nothing else has been developed, and the Clemens subdivision remains a grassy patch of land that's never had any further activity.
All right, so would it be your position that that 1/10 of Hyder Lane, that was accepted by the county?
I would argue that that part of it was covered by the county when it did maintenance work.
Okay, but the county just accepted a portion of what was offered.
Let's say the county, I would agree with that, Judge.
Okay.
The county, but at the same time, the road superintendent, Lowell Bean, who was there for 16 years, he's out now because he retired. But in his testimony, he says, I have never done anything else in there. There's never been any other progress in that. There's never been any work done. I would not open the rest of that subdivision up. It is not available unless the county road committee approves it, and unless the county commission it's submitted to them, and they say that we should open that. So it's never been opened except, as you said, that 1/10 area, which is served my client's home and 2 other homes on that Hyder Lane. Now, one of the other troubling factors of this, as I stated, was this resolution which says expeditiously. It has to be accepted by the county when the road superintendent is able to commence working and maintenance of the road, which was never been done in this case. And one of the other interesting things about the issue of whether or not this was ever accepted by the county, we relied on, in this brief, on our case of Fleener versus Drennan, which I argued that case in this court, and I was trying to say that that Allison Heights subdivision was granted to and adopted by the city of Rogersville to furnish the Fleeners access to their property because it was adopted and it joined the Fleener subdivision. I lost that case in this court. That was in 1986. But it says in there has to be not only, and there has to be an offer of acceptance, there has to be an unequivocal acceptance by the county, and in the Fleener case, the city of Rogersville, and that it was never accepted, and that unless there is a common use or a maintenance and acceptance by the governmental body to maintain those streets and create them and extend them, then there's no acceptance, and it specifically says that. Now, as I stated, Road Superintendent Bean has stated that this road, other than that 10 however long that was, I can't remember exactly what he said, was never opened up. And another trouble that we found was concerning in the judge's opinion, and Judge Jenkins, I thought, did a good job. I think he overlooked the issue that in the West Meade case, there was a 60-foot road in that case, plus sewer lines. And in the case of Borallo, there was other utilities in there which did not happen in this case. So the Fleener versus Drennan, we believe, is controlling in this case. And even though I was advocating it, that on behalf of the Fleeners, that it should have been accepted, their property should have been accepted. It wasn't, and here I am arguing the other side of the coin because that's what I get paid to do as a lawyer.
I understand.
But at any rate,
Counsel,
one of the other things that...
I'm sorry, before your time gets gone here, would you address the issue on indispensable party?
I'm sorry, Your Honor?
Could you address the issue on indispensable party?
Well, that's what I was getting ready to point out at this point.
Okay.
We felt like, in this case, that Judge Jenkins should have made the county a part of this, or ordered that the county be a part of this, because the county, in essence, has an obligation to keep this road up if in fact they did accept it. And without that being a part of his ruling, he in essence said if the county, if they're not a party, and I can't say that this has to be a county road, but if they don't do something, it will be a county road if there's nothing done by them. And I feel like the county should have been a party to this, and I also feel like that the Clemens family should have been a party to this because they have an interest in this. So the long and short of the final point I'd like to make on this before I reserve my last few minutes to rebut, Ms. Smith, who filed this suit, who is trying to have this subdivision opened, and I'm sure it's for further development, Ms. Smith had an access to the main road, and she didn't have to worry about using the access on the Clemens subdivision, but she sold an acre of that property to the Ed Weiniger family, which fronts the road that she would have had access to for the development of her property. And had she not sold that road to the Weiniger family, if she had not done that, she would not have be here. We would not be here today on this, because no matter what, this Clemens subdivision has never been open now for over 75 years, and the garage has been sitting there now for 50 years, which tells me from an adverse possession, that adverse possession applies in this case because, number one, they have continuous use of it for more than 20 years.
Who does the adverse possession apply against?
The adverse possession would apply to the Berries. And
Okay, they're not claiming.
They're the people that's claiming the garage, that the garage was built on this.
But they're not claiming they own the property.
I'm sorry?
They're not claiming they own the property.
They're not claiming they own the property. They're claiming that they built, the predecessor in title built this garage for over 50 years. In 1960, when that garage was built, that over 50 years, all those people who owned that property, and there were two other families besides the Berries, owned that and used that garage for their undivided, untested purpose.
I didn't make myself clear. Who would be the other, who's the property owner that the adverse possession goes against?
Well, the Clemens family. It's part of their subdivision that they say this garage was built on this undeveloped road, part of Hyder Lane, that they never, that was never developed. Hyder Lane is the location of where the garage.
Who owns Hyder Lane? In your client's view, who owns Hyder Lane? The part that's not developed.
The Clemens family would still own the.
They would still own the family.
Or the remnants of the Clemens family. Yes.
And they weren't a party to the lawsuit.
They were not party, and neither was the county.
Okay. All right. Thank you. You have your time for rebuttal.
Thank you.
Hear from the appellee.
Morning, my name's Todd East. I'm from the Kingsport Bar. I look at this particular matter as this is an offer and acceptance, just as Mr. Boyd stated. The offer was the recording of the plat, which set out the roadway, which was become notice to everyone from the filing of the plat. The acceptance was the resolution in 1959 by the county, and in that particular, at trial, proof was offered from an expert witness that this is the way the county accepted the resolutions at that time, and therefore we have a completed offer and acceptance. At that point, the roadway becomes part of the county, whether it's opened or not. It is part of the county until the county takes steps to abandon it. The abandonment part would have to be through deeding the property back to the property owners or some other type of action. Mere inaction does not void the acceptance by the county, and that's what we had in this case. So from our standpoint, although Judge Sweeney mentioned that part of the road's open, doesn't matter if part of it's open, it's all part of the right-of-way system, and therefore the adverse possession issue is not relevant because you don't adverse possession against the county, and that was the issue. I think the issue that you raised of indispensable party, I don't think it's relevant from our position because you don't have to get to that point. You don't get to the point of inverse or adverse possession because you just don't get that far.
Well, but the trial court held in this lawsuit that it was a public road.
Yes, sir.
What if Hawkins County says, no, it's not? I mean, what do we do? Where does that leave the property?
Well, Mr. Bean wasn't, he's my senior, but I don't know if he was in high school at the time, and so he's not with the Highway Commission in 59 when this was passed. Mm-hmm. Once it is accepted, it becomes a county road. Although the county highway commissioner may not realize it, may not understand the legal aspect of it, but it is a county road. And whether they say it is written, they own it. They own the right of way.
Does this determination in this lawsuit bind the county to anything?
Well, it doesn't bind them to develop. Well, it's a right of way, and that's the issue we're looking at. And yes, it is a county right of way.
So Hawkins County is bound by the decision in this lawsuit that it's a public right of way.
My position would be in 1959, the county bound themselves by accepting it.
Okay.
And I don't know if I could get exactly where you are. I think they've already bound themselves when they accepted it, so they can't come back later and say, no, we don't want it now, although we accepted it earlier. That's abandonment, and there's no actions for the abandonment. Yes.
Excuse me for interrupting. As I understand, the language in the 1959 resolution includes, as recommended by the county superintendent of highways, all streets and roads which have heretofore been laid out and dedicated to public use within the duly platted subdivisions located in the county shall be taken over by the county superintendent as public roads and streets. Was there evidence that there had been a recommendation by the county superintendent of highways that occur with regard to platted roads?
The proof at trial was by the expert testimony is that was the way the acceptance was done at that time. And so at that point, it became the county right of way based on the proof at trial.
Notwithstanding whether there was any recommendation by the superintendent of roads?
Well, I guess I don't have to get to that point because once it was accepted, the highway commissioner at that point, it's part of his system to service. And I don't know if I got that exactly as you did.
I quite understand. I think basically I'm just trying to ascertain what is meant by as recommended by the county superintendent of highways. Was there a recommendation? When was it? And what effect did it have?
The proof at trial was that's the way they accepted it, and it was accepted is what the proof came out at trial. And so if there was another, fallacy like notice or issues like that, that wasn't raised. The only point was from the expert testimony, that's the way the county accepted it at that time, and therefore it was accepted by the county.
Thank you.
And may not answer exactly on point, but that's what our proof was.
Yes, sir. Thank you.
Any other questions?
I hear none. Hear from the appellant rebuttal.
Very short rebuttal, Your Honor, please. First of all, at the time this proposed Plymouth subdivision was recorded, number one, there was almost no, if any, county planning commissions or county state planning commissions in existence at that time. So number one, the subdivision itself would not have met what would be required as the county requirements for subdivisions, which now requires 50 feet, then it was 30 feet. And secondly, there was never a planning commission to approve this as being a proper planning for a subdivision at that time. So no city, well, it wouldn't have been a city, but no county or no state planning commission ever would have had the opportunity to approve this. Plus, the second thing is the requirements for subdivisions at that time were a lot less stringent now than they are now. And our argument is, without the county being involved in this, and the fact that the stringents are far greater, you know, it's a lot more expense and a lot more trouble and a lot more problems for a county to take over a subdivision that was never properly approved at that time, never accepted at that time, to meet the present county subdivision regulations, or the county planning commission, or East Tennessee Planning Commission regulations, when they did not meet what would be now the requirement for that to be done. So we think there's a whole lot of reasons why, number one, the county should be made a party of this, and secondly, the fact that it says specifically in there, and Lowell, Superintendent Bean says this was never intended to be a county commission, or county superintendent, I'm sorry, a county subdivision, and that it says specifically in there that this has to expeditiously be accepted by the county when the county road superintendent is able to commence the working and maintenance of roads. And that never happened in this case. If you have any questions, I'll be glad to answer.
I hear none. Thanks to both counsel for your argument and your briefs this morning. You all have a safe drive back up to Upper East Tennessee. Adjourn court till our next regularly scheduled